motions to dismiss. You reserved, I gave you all 2 hours. I'm going to give each side 1 hour, and you can certainly do whatever you want with your 1 hour's worth of time. Okay? I'm first going to hear from the plaintiff, and then I'm going to give the movant. I always give whoever the moving party is the last word. Okay? So, you may proceed.
Well, how are you doing today, Your Honor? So since I'm starting off, there's one central overarching issue here that I think needs to be decided and upon which most of the arguments rest. That argument is whether the WSH defendants are a public agency and therefore subject to the public records law. The law is clear that all agencies are obligated to the records law under Florida Statute 119.011. The law is clear that municipal officers are defined as public agencies under 119.0701(1)B, and wherein the city charter defines the WSH defendants as city officers. So my understanding is that they would be a public agency and responsible for public records. They have made arguments about the contractor provisions where contractors, if you want records from them, there are certain things that need to be done, but within that section, they're defined specifically as a public agency, not as a contractor. The defendants have not responded to any of these assertions that I've made about them being a public contractor and cited no law to the contrary. They continue to simply argue that they're contractors like a waste management company. However, a contractor such as a waste management company would be covered under 119.071(1)A, and unlike a waste management company, the WSH defendants are a public agency, again, under 119.0701(1)B. That's, I think, a really big issue that needs to be addressed, and if, depending either way that's decided, that probably disposes of, I'm assuming, at least half of the issues. Aside from that, and at least my humble opinion, there's only two issues that I think reasonably can be argued for which there's no settled law. The first one is whether video can be redacted, as was done in requests 4 and 6. And secondly, if WSH is a public agency, being the city attorney for Homestead, are they also obligated to provide other public records in their possession, which are not also Homestead records? I guess this issue arises, one of the requests I filed with WSH was for their public billing with all the public entities they represent, upon which I've not gotten a reply or records for. My contention is that they're a public agency, they're required to produce public records, and the public records law is clear that any agency has to allow for inspection or copying of any records that are in their possession. There's nothing that defendants have cited contrary to this. I guess after that, I'll just go through their arguments in the reply that they filed. The first argument they make is that I effectively concede that I've not complied with the general pleading requirements or this court's express directives. I've taken great pains to follow explicitly what you ordered last time in the last hearing we had in this case, Your Honor. Therein, you instructed me to, instead of listing the relevant paragraph numbers for each count, to write the request numbers in, which is precisely what I had done. You had also requested that I put the dates in, and when I filed the Second Amended Complaint, I took the liberty what I thought would make it easier for everybody, because there's 3 time sections that could be relevant. There were 2 amendments to 119. One of the amendments occurred in 2016, the other occurred in 2017, so I grouped the request numbers based on which category they would fit in, because the request numbers aren't sequential based on dates. They filed motions to dismiss that, and they brought up the point that I did not explicitly follow your orders by putting the exact dates in, because I grouped them by date categories. So I filed a Third Amended Complaint primarily for that reason, to put the explicit dates in for each request. I further in there went and removed several issues that we had been arguing but had not been settled, that I felt were not completely central to what I was really going for, and I was trying to reduce, burden on this court and for all parties. So in that respect, I don't think it could be said that I did not follow this court's directives. I went through the video several times, I went through the transcripts and went word for word what you had asked me to do and did the best of my ability to follow that precisely. They did not argue this in their reply, but they argued in the response that I'd also improperly commingled the cases, and they cite some cases for that. And their argument was where I have, let's say count 1 against Stetton, there's multiple requests in there. They were arguing that should be broken into several counts, 1 for each request. But again, at the last hearing, you instructed me, since I was going for the injunction, which requires the pattern and practice, to have which request which defendant had violated. So like I said, Your Honor, I did everything I could to follow your orders to a T. Next, plaintiff's second argument in plaintiff's reply is that they state that plaintiff's claim related to the city for alleged improper advice purportedly given to the city fail as a matter of law. And this goes back to what I said the first overarching issue is whether or not they are a public agency on definition. And I completely understand the arguments about an attorney can't be held liable for giving a client bad advice. The issue is separate than that, and I would frame it wholly different. The way I look at the issue is they're a public official, and any acts that they do as a public official that lead to the unlawful non-production of records, they should be liable for. And there's several categories of records related to WSH defendants. First is the records that I filed directly with WSH defendants for WSH records, which should be pretty clear that has nothing to do with giving advice. There's other records that I filed with the City of Homestead where determinations made by WSH attorneys led to Homestead not providing those records. And as an example, if 2 public officials for a homestead, let's say the manager and the clerk, both act together to provide me from getting records, both of those could be liable. In such an instance, the city attorneys being an officer of the city, I see it as being no different than that. And then third is there were requests that I filed with the city where defendants, at least in one instance, Samuel Zeskine, had the records himself. The records were given to him within 4 or 5 days, and then he delayed a month himself before the records were provided to me. And that's not just advice being given to a client, that's his direct actions that led to that violation. In their third argument in the reply, they state plaintiffs claim that claims against WSH defendants relating to requests improperly made directly to WSH for WSH financial records fails a matter of law. Again, this goes back to what I was saying is the central overarching question is whether or not they're public agencies. If they're public agencies, then they're obligated to produce public records. And as I've argued, they're not just merely contractors, because the section that they cite for the contractor provisions actually specifically defines them as a public agency because they're a municipal officer. 1190701 defines public agencies to include municipal officers, and as I've said, the city charter defines the city attorney as a city officer, so therefore he's a municipal officer in a public agency. The fourth point in their reply is plaintiff's claims arising out of requests 1, 2, 3, 10, 12, 16, 18, 21, 22, 23, 24, 25, 26, 27 are moot. I wholly disagree that any of these requests are moot. A lot of their arguments for the mootness pertain to their arguments that the records have already been produced. But that is not the standard for mootness. To begin with, if they are found to have unlawfully withheld records, I have a right to receive costs. Not fees, but I have a right to reasonable costs, which has not been determined. So because of that, it's not moot. Further, let me see, it was Valley Transit Authority, or Lickler versus Swanee Valley Transit Authority. It's 133 SO 3D 654 655 Florida 1st DCA 2014, and therein they held that The court has not determined if the delays are justified under the facts, and for that reason alone, they said that it was not moot. And instantly, this court has not determined if the delays were unjustified. The delay by itself doesn't make the refusal unlawful, it has to be unjustified. And I've argued that under the situation that we encountered, they are not unjustified. Additionally, there are several claims, requests 2, 29, 30, 32, and 34, for which records have not been produced yet. Some of them are being withheld because they're claiming exemptions, which I'm arguing those exemptions have not been determined to be proper or improper, so clearly there's still a justicable matter before this court, which keeps it from being moot, and that also goes to the right to a declaration or injunction as well. Their fifth point, plaintiff claims against WSH defendants in their official capacities as attorney for the city are redundant to the claims against the city and should also be dismissed. Again, this is another one that goes directly to the central issue of whether or not they're public agencies. And there are requests that were sent just to WSH that were not sent to the city. So therefore, WSH should be a proper party to the suit. There's nothing they've really shown other than cases. A lot of it was federal law where naming official in their official capacity and a municipality was redundant and was redundant for claims. There's other cases, including, like I guess WFTV versus Robbins. In that case, you know, a public official was sued in her official capacity for actions she directly took in her official capacity. And I don't see any reason why it's not proper to have WSH listed, at least because of the fact that there are requests that were sent to them, not to Homestead, and the records, such as the records for their billing for the other municipalities. There's no way Homestead could force them to give me those records. So I think they are a proper party for that respect. Their sixth argument, many of the requests that are subject of the Second Amended Complaint were submitted well over 4 years ago, and as such, claims based on the request are time barred. I would disagree with that, Your Honor. Some claims were beyond 4 years from when I filed the amended complaint. They were not beyond the 4-year time period from when I filed the initial complaint, and they should be treated as a relation back amendment under Florida Rule 1.190. With regards to Rule 190C, the Florida Supreme Court held it to be liberally construed and applied. Further, Flores v. Risk Comp Industries Incorporated, which quotes Keel v. Brown and also quotes, Anderson v. Epstein quoting Flores v. Risk Comp Industries, which also is quoting Keel v. Brown, held that the proper test for relation back amendments is whether the initial pleading gives fair notice of the general fact situation out of which the claim or defense arises. In the initial pleading, in my initial complaint, I clearly stated that I had been filing requests with the City of Homestead over the course of several years. I clearly stated that there were approximately 100 records requests that were filed, and the majority of those I believed had been violated. I then stated that I added that the requests were I also added that in the interest of brevity, that not all of the requests were elaborated on. I was hoping initially with the initial request that we could find some issues that they had violated and we could determine if they had or had not violated, and we would move forward and they would stop the violations. Very quickly that became obvious that that was not going to be the case, and then so I extended the complaint to add those other requests, which I had initially thought were violations and had initially tried to put defendants on fair notice of. But in the interest of judicial economy, I tried to avoid having to deal with so many requests. I thought 3 requests would show the rough pattern that I was trying to demonstrate, which it continues to be argued. And at that point, it became obvious that I needed to show more to clearly, beyond any reasonable doubt, establish the pattern that unlawful and unreasonable and unjustified delays were being made. The 7th point in their reply, plaintiff improperly attempts to relitigate issues arising out of request A. As such, claims are barred by the collateral estoppel and must be dismissed. In responding to this, and actually responding to everything, I had a hard time being torn whether I should just file a motion to strike. The arguments that are made by defendants here are just beyond reason and aren't pertaining to the facts of the case. In the related case, what was litigated was Request A. Request A was filed in 2015 before the statute of limitations for a claim against the city had expired. Instantly, Request 2 and Request 34 are being litigated. They're separate requests. They were filed at separate times, and they were filed after the statute of limitations for a claim against the city had expired. I provided as an exhibit, let me find it, I believe it's Exhibit A. Let me just make sure here. No. Exhibit C in my response was an email. That's an email between Edward Guedes and Mr. Zeskind. They were the attorneys representing the related case. And in that case, they admit that the statute of limitations had ran. They state, we cannot raise the SOL issue, or at least have to be careful how we address it, because technically the SOL has run on a claim against the city as of late last month. That was an email between the two attorneys when they were discussing the other case that I've now gotten from public records because that case has expired and so the exemption no longer applies. Defendants have not responded to the exhibit, they have not responded to the evidence, they have not responded to my arguments. They continue just to baselessly argue that I'm trying to relitigate Request A. I'm not relitigating Request A, I'm litigating Request 2 and Request 34. The facts of them being different, them being filed at different times, particularly the requests that are being litigated being filed after the statute of limitations, which opposing counsels, at least amongst themselves, admitted the statute of limitations are up. And the case law is very clear that those exemptions are temporary. Those exemptions require there to be a liability against the municipality. And while they have argued in this court determining the related case that they were intertwined, so the exemption was proper to be claimed, the running or tolling of the statute, or the running of the statute of limitations period makes it to where that liability is no longer there. The case law I cited in my response was also very clear that they're not allowed to continue to maintain records as exempt, even if it would hurt their position in related cases or related claims. And that's kind of herein what is the case, Your Honor. There was a defamation case that I have against Merguido solely in his individual capacity. It doesn't name the city. The city's not named as a party. The claims and the facts state that Merguido made his defamatory comments in his individual capacity as a private citizen. I have a federal case that is tied to that for First and Fourth and other amendment violations of mine, upon which is being litigated. However, that is a separate case and a separate issue. And like I said, as the case law holds that even if releasing the records would harm their position in a subsequent or related case or claim, once any liability or the time for the claimed exemption is expired, they must release the records. And again, I'm not trying to be iterative here, the statute of limitations against the city has ran for the defamation claim. Therefore, the defamation records should no longer be exempt. The records that they have in risk management or work product or insurance claim files that are in the federal civil rights case are exempt. I'm not arguing that those records are not exempt, but those are two separate sets of records. Those are two separate cases. Those are two separate claim counts and sets. And to hold because one case is still ongoing, the records in the other case are not available, flies against all the case law and case law that I had cited in my response. In their reply, their argument 8, plaintiff's claims relating to requests 4 and 6 fails a matter of law and must be dismissed, as the city is entitled to redact images of active law enforcement personnel. This was what I said was one of the issues that I think could be reasonably argued by either side. I completely disagree with their arguments. However, What had happened is initially I'd filed a request for some dash cam footage, and when the video, where I got a charge for $450, I was requesting the video on behalf of somebody else. That person later on their own filed their own request and received the video. And the video is about 24 minutes long, and a few minutes near the end of the video, there's a black mark that's going over top of the police officers that obscures the police officer's identity. In the invoice that I received, there was 17.25 hours charged for the redaction of the video, which one, I'm arguing is wholly unreasonable for the amount of time based on the short amount of the exemption. When the person I had filed the records request for got the video and saw that was redacted, she requested of Mr. Zeskind unredacted video and asked why the video had been redacted. Mr. Zeskind responded citing Ramses v. Deming in that case in support of the redaction of the video. In the Ramses case, though, the section they cite, and they cite again in their reply, it's not from the holding. It's from, the facts of the case, and the part that they cite is actually the part that when they were stating what the sheriff was contesting. The actual holding of the case states, we hold that the disclosure to a defendant during discovery of unredacted versions of undercover police surveillance recording does not destroy, in a public records context, the exemptions contained in section 119.071 for information relating to the identity of undercover law enforcement personnel. In the exemption section of 119.071, 4C is one section. It states that any information revealing undercover personnel of any criminal justice agency is exempt from statute 119.07 section 1 and from section 24A article 1 of the state constitution. 4C is not the section of exemption they claimed. The section of exemption they claimed was 119.071 4D. 4D specifically holds that certain information about former or current sworn law enforcement officers is exempt. That includes their home addresses, their phone numbers, their social security numbers, and photographs. However, let me find this real quick. In the definitions, which is under Florida statute 119.011, section 12, it gives the definition of public records. And it states, public records means all documents, papers, letters, maps, books, tapes, photographs, films, sound recording, data processing software, or other material regardless of the physical form, characteristics, or means of transmission made or received pursuant to law or ordinance in connection with the transaction of official business by an agency. Within that definition, it clearly differentiates between photographs and film. At the time this was written, we didn't have digital recording devices the way we do now, and film is the same as video, or video today is equivalent to a photograph. They appear to try to argue that a video is merely a compilation of photographs, and while technically I would agree with that, that's not what the law holds. The legislator very clearly recognized the difference between photograph and film or video. Yet in the exemption under 4D, they only exempted photographs. If they wanted to redact film, they should be able to redact. I mean, they should have it in there. What defendants are asking is they're asking for the court to create a judicial exemption, and the judiciary cannot create a privilege of confidentiality to accommodate the desires of government. And at least one case that held this was Times Publishing Company versus the City of St. Petersburg, and that was at 558 SO2D 487 and 492. To create an extra exemption would be improper for this court to do. And also case law held very clearly that the statute is to be liberally viewed in favor of production and records, while the exemptions are to be narrowly construed for their stated purpose. They've argued that the stated purpose is, security and safety of police officer, which I clearly understand, but that is not to add film to that would be extending the exemption and judicially carving out an extra exemption for the defendants, which I don't believe is proper. Further, it kind of flies in the face of what we see all the times regularly in the news media and elsewhere. We see dash cam footage, we see body cam footage, in the news, on social media, and we never see that footage is being redacted. While I don't contest that they can redact a photograph, I contest that they can redact video. And I won't belabor that point any farther for that. Other than the fact that the law does not allow for the redaction of video, and the time they're spending redacting the video, I believe, is leading to excessive charges. Point 9, their last point, is they argue that plaintiff is not entitled to the declaratory or injunctive relief sought. I responded to this in my response, and I'll talk about it for a little bit here as well. For me to be entitled to declaratory or injunctive relief, there needs to be a justicable issue. It should be beyond reason to see that there is a justicable issue here. I'm claiming that there's exemptions that don't apply. They're claiming there are. I'm claiming that there's delays that are unjustified. They're claiming they're not. I'm claiming to have a right to fees and costs, or not, I'm sorry, not fees, costs. I'm barred from fees, but I have a right to costs. They're claiming I'm not. These issues all being open make it to where it's not moot, and there is a justicable action that can be held. Let me find this real quick. And I'll go back and talk about WFTV Robbins for a minute. Defendants have argued against me citing this case, where I cited to show that a public official could be held and you didn't have to sue only the municipality. The interesting thing about WFTV Robbins is, in that case, they held that because both the determination of records to be produced had not been had, and because costs had not been had, that it was not moot. And they remanded it back to have that determined, and to determine if mandamus or other equitable relief would be granted. Being a pro se, I might have been mistaken, and maybe it's mandamus relief I'm looking for and not declaratory relief. However, I think that at some way there needs to be made a determination of whether the specific requests that I'm contesting were violated for the reasons that I'm contesting they were violated. And if so, does that establish a pattern that allows for an injunction? Just for the cost for a second, again, excluding fees, which I'm not allowed to, for costs, the courts have held that a plaintiff is entitled to reasonable cost of enforcement. In the case that held that was Weeks versus Golden. It's 764 SO2D 633. And that was the Florida 1st District Court of Appeals in 2000. Also, WFTV versus Robbins held that a case is not moot if costs have not been determined. And then, again, Lickler versus Suwannee Valley Transit Authority held that the court had not determined if the delays are justified under the facts. And if the court had not determined if it was justified under the facts, it's not moot. And it's something that needs to be determined. And if it is determined, I don't know if you just say it's determined, or if you say you declare it, or if you say you issue mandamus. I'm a little confused on exactly what it was in terms of equitable relief based on the wording there. In terms of an injunction, I'm very clear. I think there was a pattern that's been established, and I think that that pattern entitles me to several injunctions. In terms of arguing the injunctions, one of their arguments is that I've just made broad blanket claims for them not to violate the law. And they are correct. The law is very clear that the court cannot issue a blanket injunction enjoining any violation of the law in the future, but the courts have ruled that a court can make an injunction that reasonably relates to violations that were been made in the past. The reason I had 9 separate requests for injunctions there were the nine separate ways that I believe a pattern has been established of refusal to produce records, and therefore if injunctions were had on any or part of those injunctions would clearly put the defendants on notice of what it was they could or could not do, and not be just mere speculation and not be just a mere declaratory or advisory opinion, which I know is prohibited by this court. Another issue I guess they had argued in my right to declaratory relief is that there's no showing that there's doubt. I think the fact that I'm arguing the case law says one thing and they're arguing the case law says the other thing clearly shows there is doubt, particularly when, for at least the issues where there's no settled case law that specifically says who is right or who is wrong. And then in the other issues, you know, for the delays and else, I'm arguing that they're unjustified. They're arguing that they're not. Clearly there's doubt there between them. Based on their reply, there's not that much that I would have left to go over to say. I had also requested that if we could, if we had time, that we could make a determination of whether I was entitled to certain records that they had not produced. Since I guess I have plenty more time that I haven't used up, I'll go ahead and go through this briefly, not to try to make this an issue of that if we're not having a hearing on my determination of entitlement here, but because it also relates to their motions to dismiss and claiming that I don't have records. There's three issues, or I guess three sets of records where I'm requesting records that they have not provided. The first one is the defamation records, which I've already argued. You know, request A in the other case was filed before the statute of limitations, where requests 2 and 34 in the instant case were filed after the statute of limitations. And since the statute of limitations has run, the exemption should no longer apply and those records should be produced. The second one is the public billing from WSH, the billing that they sent to their other municipal clients aside from City of Homestead. If we just focus on the billing records with the City of Homestead, although I filed the request to WSH, the city replied. In replying, the city stated, I believe it was like $2.237 million or something they had paid in 2013. No records were provided for that. The clerk just stated a number with no records to provide that. Aside from not providing records for the City of Homestead, again, I think as they're a public agency, all public records in their possession which are not exempt should be provided and should be available for inspection and copying. This includes their total billing for the other municipalities. They're arguing that I want to go in and go through all the records and go through everything. I would actually waive my inspection right for their billing if they would just provide me the documents of their total billing. I don't want to know how much they've charged for each case. You know, what I'm looking for is City A, $2 million, City B, $500,000. I mean, such a large law firm, it should be fairly easy for them to know how much they billed each one of their clients on an annual basis for the years that I had requested. And I find it just superfluous that, you know, one, they're failing to even respond to the request or acknowledge the request, but then they're claiming that somehow or another these records would be exempt because I didn't ask the city that's representing them. And this goes back to an issue that you brought up last time is, if several agencies are in possession of records, I don't have to go to each agency waiting for each agency to refuse. I can request the records of any one of the agencies. I haven't been able to determine all the agencies that WSH represents. I mean, if they wanted to provide me with a list of every government client that they have that would be subject to the records law, I mean, I guess I could go and file records requests with all of those. But again, you know, that's not my obligation under 119 to do that. If they're in possession of the records and they're a public agency under 119, it's their obligation to, you know, produce those records. And the third part for records I was asking for was unredacted billing records. And let me find, so I can check exactly which exhibit it was. It is Exhibit C, and it was in the motion I filed for termination of immediate hearing. Let me get it. If I could approach the bench, Your Honor, I'd like you to see this record.
Thanks.
What you see there is an invoice that's from a third party. This invoice actually relates to this specific case here, Your Honor. And so the way they, WSH normally does their billing, the way I see the billing, is, you know, that they have their name, their header at the top, and then they have a date, the initials for the attorney working on it, a brief description of what the time was for, the number of hours, and then what the dollar charge is. At the bottom of that, it totals it all up to show total hours and total billable hours. Then below that, it shows disbursements. You know, they'll have disbursements for $100 or so for a court reporter or for transcripts or things like that. In their billing, one of the disbursements was actually redacted. I don't believe them dispersing should be able to be redacted, and the amount was for $618.75, which is from like their actual billing. This invoice that I showed you corresponds to that disbursement payment, also $618.75. When you look at the invoice, what is redacted is what must be assumed to be an address, an email address, an item number, a description, an adjuster's name. They claim that they were able to make these redactions under the attorney work product provisions. The attorney work product provisions only allows them to hold as exempt material that was prepared by or at the express direction of agency or attorney that directly reflects a mental impression, conclusion, legal theory, or litigation strategy. It is beyond prima facie that